lawyers slots. So
okay, so,
so thing gets delayed.
It's quite a vicious system which is at play. Discussing the stalemate between the judiciary and the executive over the appointment of judges. Dr. Jaswal, what is the system in other countries? I believe in some countries the executive has the final say, and in some countries there is a system of both having some kind of a say.
Yes, in some country it is the executive which has the power to appoint the judges of the Supreme Court. In other countries it is the judiciary which has the power to appoint the judges.
So which system seems to be working better?
Well, I think in the Indian context it is the balance between the two systems that is the better.
Dr. Garewal, what is the system that prevails in UK? I believe there has been a change
yes.
in the last couple of years.
In 2005 or 6, they set up a Judicial Appointments Commission, which was incidentally headed by Mrs. Usha Prashar, who was a member of the House of Lords. And she was a layperson, but it consisted of 5 judges and even had some law professors and had some magistrates on the commission. So you would have a magistrate sitting on a commission to select judges. They would ask for applications, people would apply, and they would be called for interviews, and their biodata would be checked.
So what is the feedback that is coming from there?
It's very good, very fair. Well? It's very fair. Well. You see, the candidates feel they have been fairly treated. That is
right.
one advantage.
Dr. Jaswal, one of the issues before the Supreme Court now is whether the constitution can be amended by a judicial verdict, or can it only be done by the Parliament under Article 368?
Well, if we see the constitution, the amending power is only with the Parliament of India, not with the Supreme Court. But Supreme Court is the guardian of the constitution, and they do give interpretation to the provisions of the constitution. And under Article 141 of the constitution, whatever the Supreme Court says by way of a judgment, that is as good as a law and binding on all the courts within the territory of India.
But I believe there is no mention in the constitution of a collegium.
No, the
so
collegium
after 93, how come the verdict of the Supreme Court never got discussed either in the Parliament or was never challenged before the Supreme Court itself?
No, the collegium does not exist in the constitution anywhere till date, that I agree with you. But it was the judgment of the Supreme Court which was, as I said earlier, binding under Article 141. And as Justice Garewal pointed earlier, the main drawback of the collegium is not favoritism. The main drawback of the collegium has been not filling up the posts quickly. There has been a time gap, and it is due to that it has come under a criticism.
So don't you think in some ways whatever the Supreme Court did was kind of riding roughshod over the constitution?
Not a roughshod, because the past experience of 1973 was probably fresh in the minds of the Supreme Court, where the executive tried to pack the Supreme Court with its own chosen judges, or the 3 senior most judges were superseded in Keshwananda Bharati case in 1973. The judicial independence is of a...
So maybe at that point of time this was the need of the hour.
That was the need of the hour at that time.
Surprisingly at that time, Indira Gandhi wanted to appoint Mohan Kumaram Mangalam directly as the Chief Justice of India.
You should have played havoc with the,
Exactly. So those those memories must have been
again,
fresh.
The very point I am making, you cannot give everything to the executive.
Absolutely.
If you give everything to executive, the judiciary will just collapse, slowly it will collapse, and it is being attacked, and then attacked from those people who are so powerful, the executive. Then you can't, you've got to keep its independence.
But Justice Gill, there is a feeling that whenever the Chief Justice of High Court is appointed from outside the High Court, he is not conversant with the antecedents of the lawyers who are to be elevated. And many a time, the other members of the Collegium are either sidelined on one pretext or the other, or not taken into full consideration.
That you are correct to a certain extent, that yes, when the Chief Justice comes out here, either he is going to retire very soon, he is the least interested, or he is going to go to the Supreme Court. Then he starts recommending names on the asking of beyond what is meritorious to him. And we had a Chief Justice lately, and I was J1 that time, and 3 times in February I talked to him, in May, first week of May I talked to him, and then I went abroad, then I came in the first week of August I talked to him. I asked him, let us send names. Everybody is saying send names, we are not sending names. And he said, all right, we will send names, we will call a meeting of the Collegium. And I retired on 30th of August, and the 2nd of November he called a meeting of the Collegium.
October.
Obviously, he was waiting for me to retire. It was very obvious. So here, you know,
so there is a way to even sideline the Collegium system.
Collegium, I was J1. I have a member of the Collegium since August 2007 for 3 years. And with my signatures, there are about 15 judges who are sitting on the bench today. And what was wrong in I recommending or suggesting to my Chief Justice that these are, after all, I practiced out here, I've been a law officer out here, I've been a judge out here. But well, he was just passing his time and saying, so yes, I'm retiring, why should I bother now?
But it is another matter that even those names which are sent, I think, still haven't found approval yet.
They should not be given approval to. I'm very clear on this. He was just waiting for me to retire. It was obvious. The circumstance, I won't name him. The circumstances are telling. He was waiting for me to retire. And then he recommends the name on 25th of November, 26th of November, when he is going to retire in another 35 days. You know, there are flaws.
I think that's the reason why even those names, got stuck.
I will put it in a big. It's very, very important to have a Chief Justice who is totally honest to the Collegium system. There will be no flaws in it. But if the Chief Justice is not honest to the Collegium system of recommending names, there are going to be flaws.
I will go to the extent of saying that Chief Justice should be from the same High Court. This system of having Chief Justice from outside the court is not working well. It is weakening the judiciary.
But Justice Garewal, now there is a system that the Chief Justice who is to take over is sent to a High Court a few months before that, and he gets familiarized with the system.
It's not the same thing. You would have a Chief Justice of the High Court, a person who has been a young lawyer, who has worked his way up the bar, or someone who has joined the service, who has been in the state. He will be in a much better position to make a proper selection, rather than somebody coming from outside who will, well, in a few months he'll ask here and there and then come up with a list.
But well, that's the issue of a wider debate. Dr. Jaswal, in your opinion, what should be the system of the appointment of judges?
I think the foremost point which we must take into consideration is that the independence of the judiciary must be maintained.
How can that be done?
Now for that, the Chief Justice of India, as I said, a person of an integrity, a person of fairness. If he consult the judges as it is provided in the Constitution also, that is fair enough. But the moment we give this or tilt the balance and give this total power to the executive, the independence of judiciary will not be there.
So what you're trying to say is that it finally comes down to the individuals who are there, and that's why we need a system of checks and balances.
The Chief Justice.
The Chief
the
Justice.
Individual will be the Chief Justice, because he is the one who is controlling things.
The consultation process is not bad, it is good, but we can't totally give the power to one organ.
Justice Gill, in your opinion, with your experience also, since you are a member of the Collegium, what is the right system of the appointment of judges?
Collegium system, I feel it should be maintained. Again, repeating what I said before, it is the judges who can judge the advocates as to who should be. But going on a wider scale, if I go on a wider scale, times are changing. We've got to have competition out here. We've got to have all India Judicial Service Act, where 50% come from the All India Judicial Service or whatever the act is.
Yes.
Whatever the selection process is, it should be competitive, like the IS, IPS, and all. And 50% must come from the bar and from the promotees. This getting all the High Court into the High Court from either the promotees or from the bar, and on the basis of what the Collegium wants to say, it is too arbitrary.
The system
there are lawyers,
is too arbitrary.
To be very frank, there are lawyers in the High Court today. There are lawyers in the High Court who should have been judges in the year in the 90s. There are judges. Justice Garewal will bear me out. There's a lady, I will not name. There's a lady lawyer till today who should have been on the bench another 15 years back, but she's not being there because there are judges sitting trying to hit her out for certain reasons which were not in her hands. I'm giving just an example, and there's so many lawyers sitting out there. If there's a competitive exam, they'll sit down and come onto the bench.
Justice Garewal, in your opinion, what should be the system of the appointment of judges? Now, you have very wide experience even in the United Nations.
Well, I'll say, I can tell you a bit about my selection in the United Nations Tribunal. They circulated the vacancies, which came to us officially through the registrar, and we were all asked to apply. We applied online, and they asked for our judgments, and then they shortlisted the candidates. So I'm not sure how many applications they got, but I was one of the shortlisted candidates, and we were called to The Hague for an interview and a written test. And this was conducted by United Nations Internal Justice Council,
But this is interesting, even at that level there is a written test.
Yes, there was a written test. It was 2 hours. They gave us a file and they said, please decide this case. So I read it. I was totally unfamiliar with the regulations of the United Nations and Universal Declaration of Human Rights and so many other, they gave us a big thing. So, sat and did it. Everyone did it. Everyone had a fair chance.
Very interesting. So with that experience now, what do you recommend? What kind of a system should we have?
So I would examine the UK experience little more and see how they are faring. I believe I was speaking to Mrs. Prasher. She was here about 2 years ago, and she told me that for I think 30 posts of High Court judges, they had 150 applications. So lawyers were applying. So the lawyers who apply, they feel they can be judge of the High Court. So when they come before the committee, they have to then convince the committee that they are the right material, and the committee can also ask them questions to test their competence, their legal knowledge, and their they can also have checks, integrity checks, background checks. So that way you select a good candidate. Everyone feels satisfied and convinced that they have made a good choice.
Very interesting suggestions. Dr. Jaswal, do you think the list of people being elevated can be made public or should be made public for a peer and public scrutiny?
I don't think that we should go to the public for such a high post. Ultimately, whether it is a collegium or whether it is a judicial commission, we are the people who are going to man it. It depends who are in the process, who are involved. This actually, it is not the particular system which has failed. We have failed a particular system.
We have failed the particular system.
The standards are very high.
Justice Gill, should the people be elevated to the bench where they have been practicing all their life? Now the question often comes in that their own kith and kin could be practicing there.
Kith and kin issue is completely different. But where they've been practicing, selection of a lot of advocates will be, they will not come onto the bench. If you're going to tell them, if this kith and kin is not practicing out here, he will say, sorry, I'm happy out here. Nobody wants to go to Assam, nobody wants to go to Tamil Nadu. And you will lose out a lot of lawyers if you...
Just before we close, last word from you. Should people be elevated to the bench where they are practicing?
Yes, why not? Why not?
No harm in that.
Not at all.
Yes, absolutely right.
Thank you very much, gentlemen, for joining us in this discussion. From past experience, it is apparent that neither the pre-1993 system nor the post-93 system of appointment of judges has worked to satisfaction. Surely there is need for a fresh system which ensures not just checks and balances but also complete transparency. With that, we end this edition of Prime. We meet again tomorrow with another issue. Till then, good luck and goodbye.